With the non-admitted and reinsurance reform implementation deadline looming, California is gearing up to comply with new surplus lines regulations. In this interview with Insurance Journal's Patty Tom, insurance regulatory attorney Richard Brown shares what effects the NRRA will have on surplus lines insurers' eligibility.
Under the NRRA, they established basically two prongs for surplus line insurer eligibility. One is if the non-admitted insurer is on the NAIC quarterly list of alien insurers, then a state may not prohibit a surplus line broker from placing a risk with any of those insurers. Second, if the surplus line insurer meets the state's minimum capital and surplus requirements, then the broker can place the risk with that insurer. Now, the minimum capital and surplus requirements that they incorporated by reference from the NAIC Model Act, and that was $15 million. But California has raised the bar on that to $45 million. I believe New York's going to follow. Other states will follow. $15 million was just way too low. In AB 315, what California has done is they've taken the old Leslie procedures, list of eligible surplus line insurer procedures, and they have replicated them in a new section of the code, section 1765.2. But they have replicated them as a voluntary standard. If the insurer complies with these new procedures, now called, instead of list of eligible surplus line insurers, it's the list of approved surplus line insurers. So keep track of Leslie versus Lastly. All of the Leslie insurers are grandfathered on Lastly effective July 21st, 2011. So the brokers just need to look to the Lastly list, and they will see the same insurers that they saw on the Leslie list.
Brown cautions brokers should not assume that they are insulated from liability.
One other point perhaps worth making is that because this is approved by the state under the new Lastly list, just like under the Leslie list, there is some notion that surplus line brokers are insulated from liability, that they don't have to make an independent judgment about the financial condition and reputation of the non-admitted insurer. I'm not sure that that actually works because there's no statute in California that provides that kind of insulation. But there is kind of a notion in the industry that that's the case. Nothing's really going to change for surplus line eligibility in California as an operating matter for surplus line brokers. There are some nuances to it, but there's not really time to get into that here. Right now, don't worry about surplus line insurer eligibility. Just look at the new Lastly list.
More information from Richard Brown on the effects of the NRRA can be found at insurancejournal.com.